Hi everyone, this is Arkady Frekhtman, a New York City personal injury trial attorney, and today I'm coming to you about ATTY Law. It's a new enterprise that's just been launched, and I think they have Series A financing, about $14 million, and they're trying to change the way personal injury law is practiced. So I wanted to just talk about it briefly and get your opinion. Is this really a new generation of personal injury lawyers that are going to be more client focused, really helping injury victims? Or is this just another ploy or marketing tactic to try to get clients? So if you haven't heard about it, ATTY Law started as Mighty, and Mighty was a company that dealt with legal technology. So what they did was their clients were attorneys, personal injury plaintiffs attorneys, and they would help those attorneys deal with financing, lien holders, and I believe they had like a CRM or a software that made things more efficient. So for example, if I was a personal injury lawyer and I worked with this technology company, so what they would do would be they would help me figure out my lien situation. So I might have a settlement for a client like Bob Smith, right? Bob Smith's case settled for $10,000, but Dr. A has a $1,000 lien. I'm calling Dr. A, his secretary's not calling me back. So he had some kind of software where it would make it easier with Medicaid liens, Medicare liens, all types of liens, mostly medical providers, but I believe they also dealt with financing. And so it was like legal technology, and they had all this information. And now what they're doing is they're actually launching a law firm, and they actually have lawyers in 3 states. I believe it's Georgia, Connecticut, and Texas, and they want to go across the entire country. And the platform that they're launching this on is they're trying to say that Billboard lawyers are bad. You know, the typical Billboard lawyer, like I'm the hammer, or I get all this money from my clients. And what they're saying is that even though there's so much technology and innovation, and a lot of it is applicable to law, like with their own company, right? Even though that exists, the lawyers are not passing the savings on to the client. They don't really care about the actual injury victim, but they're just kind of pocketing the money. So they might be more efficient in terms of cutting their costs, or making the litigation more streamlined, or being able to settle cases, but it's not passing down to the end user, and the client is the entire reason you have a personal injury case, right? You don't start a personal injury case so lawyers can get rich, so doctors can get rich, so funding companies can get rich. You start a personal injury case because you are hurt and you want justice. And so they're saying that's their mission. And the way they're trying to accomplish that is they are talking about the typical Billboard lawyer and why the Billboard lawyer is wrong. And they're saying like a Billboard lawyer will just advertise that I get a lot of money from my clients, right? But in reality, what Mighty says is that most cases settle for $30,000 or less. And so they propose a new code of conduct. And the code of conduct basically is that the lawyers should charge 10% less than the industry standard. So for example, if most lawyers charge a third, 33%, they want to charge 30%. And it can make a little bit of a difference, especially on the smaller cases. I think from reading their website and reading the biography of the CEO on LinkedIn, and also reading an article about this new venture that they're starting, it seems to me that Mighty could be good for small cases that settle anywhere from $5,000 or maybe up to like $30,000, that range. Any more, and their model doesn't really apply, and I'll explain to you why. So 10%, for example, would be a savings. Like if it's a $10,000 settlement, the lawyer would take $3,333 under the industry standard. But under Mighty's 10% less, the lawyer would only take $3,000. Now the client is getting $300 more. So on a smaller case, it could be something substantial, $300. It's not huge money, but it's not nothing either, So then the second thing that they talk about is that there's going to be a 60-day test with no fees owed. So for example, if the client hires a Mighty lawyer and they have 2 months, 60 days, and they're not happy for whatever reason, there's no fee earned by the Mighty lawyer. The client could just leave. This, I don't know. This, I think, is more marketing because any client could leave any lawyer at any time with no fees owed, right? The lawyer is fronting the fees. The lawyer is paying and advancing the costs of the litigation, whether it's, experts, whether it's filing a lawsuit, it's $200 here in New York, $210. All of the costs are being fronted. If the client's not happy with the lawyer, whether it's 30 days, 1 day, a year, the client could just leave the lawyer. The lawyer can still have a claim for a legal fee, but that doesn't affect the client because the client gets 2/3, right? That's the client's share. Whether the client has one lawyer or the client ends up getting 2 lawyers, 3 lawyers, even 10 lawyers, it doesn't matter, right? If he has 10 lawyers, those 10 different attorneys now just have to share the legal portion. But the legal portion is 30%, right? Or 33%. That's the legal portion. So they just share that. An example, if a case settles for $100,000, the client gets about 70. And if he has 10 lawyers, the 10 lawyers share the 30,000, either by stipulation or if they can't agree, the judge can determine it based on the proportionate share of the work that each performed. So there is no, so the client is always free to change lawyers. So I think this one, I don't know. This one, I don't really see what the point of it is. And then the third point in the code of conduct is actually that the mighty lawyer must work with mighty the technology company, but at no additional cost to the client. And this also is kind of like a restrictive covenant because now the lawyer has to work only with their technology company, right? Like I mentioned before, they have some savings with lien holders, some kind of software, but maybe there's another company that does a better job either with Medicaid, Medicare, document templates, financing. There's a lot of things that go into litigation. And that's also what they're trying to accomplish because I think the CEO, it's a man by the name of Joshua Schwadron or something like that. I think what his background is in financing, right? He used to own or work in a third-party litigation financing company where a personal injury plaintiff would say, hey, I need money. They would get money and then that principal would grow. And then at the end of the case, they would pay back the principal and interest. And so now he's switching and he's doing this mighty law. So that I don't know about this thing that you have to work with mighty. But the thing I did like about it is that their mission and their vision seems to be good. It's kind of similar to ours, right? They're trying to help serious injury victims and their families. They're saying that they want justice for the end user, for the client, the person that's bringing the lawsuit. And so the other thing that they're doing is they're doing a cost sharing with clients. So 10% of costs will go back to the clients. And costs are things like filing an index number, expert expenses, case costs, medical providers. Sometimes doctors will do medical care on a lien, meaning they have to be paid at the end of the case and they've treated you for free. But all of those costs, expenses, disbursements, out of pockets that you need to spend in order to have a case, 10% of that will go back to the client. And his reasoning is that he wants to incentivize lawyers to keep costs down because he feels like maybe lawyers are trying to increase costs since they get all the costs back and maybe some of it is unnecessary. Now, I tend to agree with him on the smaller case. For example, if you have a case that settles for $10,000 and there was a lien and a patient was treating with a physical therapy provider, let's say. Now, $10,000 settlement, the lawyer gets 1/3, so that's about $3,000, right? The doctor might say, well, I gave you all this medical care for a year, physical therapy. I need at least $3,000 for me. So now you give $3,000 to the doctor, and then you might have some expenses on the case, some costs. So now there's not that much left to the client. Especially what if the client also needed to borrow some money? He took an advance, right? And he said, or she said, hey, give me $1,000 or give me $1,500. And they got that money. But now that $1,500 turned into $3,000. It doubled, right? Because the case might take a year. So now they owe $3,000 to the funding company, $3,000 to the doctor, $3,000 to the lawyer. What's left for them? Like $1,000 out of the 10? So in that sense, yes. Case costs should be reduced and some of those 10% going back to the client is a good idea. Now, in a bigger case, if you have a really strong case, let's say a traumatic brain injury or a spinal fusion, a trucking accident, anything serious where you have large limits like $10 million or more, there it's the opposite, right? Because if incentivizing lawyers to keep costs down, well, now guess what? The lawyer's not going to hire the best doctor. He's not going to pay the doctor $15,000 to come to court. But without the doctor, how are you going to prove the case? He's not going to hire an economist, which might cost money, but the economist will help prove lost wages, which are economic damages, which could be enormous, right? It could be into the millions of dollars. So there, it's the exact opposite, right? The lawyer should be spending money, because spending money and hiring the best experts and taking a gamble is what will result in a really big verdict, like an 8-figure verdict for $10 million or more. So that's completely different. So I think like his model applies to the small cases, anywhere from like $2,000-$3,000 up to like $30,000. And the other thing he talks about is gifts. He doesn't like the idea that sometimes funding companies will give gifts, or or medical offices might say, look, I'll refer a case to a lawyer, but then the lawyer has to refer a case back to the medical office. Any kind of bribery or gifts, or I guess funding companies, they might want the lawyer to, if the lawyer has a client looking for funding, the funding company might say, hey, come to me. So they might buy the lawyer lunch, or offer the lawyer like Yankee tickets, or take them to a show or whatever, any kind of gift. So he's against that. So he's basically trying to clean up the industry. The one thing that I was thinking about, though, that I didn't like is the idea that the entire company started by getting data through lawyers, right? So personal injury attorneys worked with Mighty, the technology company, and they gave all this data, which is information on their clients, right? The clients' names, the clients' incomes, where the clients live, how the accident happened, what the potential values are for the cases, right? Who the lien holders were, like what doctors treated them, whether they had Medicare, Medicaid, how much funding they took. So now Mighty, the technology company, working for many years, compiles all this data, just like Facebook got in trouble for this too, right? They have all this data. So now they use the data to then say, you know what, we don't want to be a technology company anymore, or that's not the only thing we're going to do. We're going to pivot, and now we're going to start our own law firm, but using that data. So essentially, they're now competing with the personal injury attorneys who gave them all this data, and by starting their own law firm. So that part of it is a little bit unethical, or I don't know if that's proper. And I think the way that they position themselves is they say, oh, we're whistleblowers, we're disrupting the industry. This industry has had the same fee structure for decades and decades. It's never changed. So we're innovators. Like I said before, the vision is definitely there. Whether or not it works out in practicality, we'll have to wait and see. But I'm always for helping the personal injury victim. I think that's the entire point of any type of lawyer, right? The lawyer should be a guide. The lawyer should work with the client. The lawyer should help and facilitate and make things more efficient. I hate it when lawyers talk down to clients, or say, I'm not going to speak to you, or you don't know anything. You just have to listen to me. I'm the lawyer. You're nobody. That's no good. And also the fact that, like the example I gave with the 10,000, where 3 goes to the doctor, 3 goes to the lawyer, 3 goes to the funding, and then there's only 1,000 left for the client. That doesn't make sense, right? Because the heart of the case, the reason you have the case, is the patient, right? The personal injury client. That's why everybody exists. If there was no car crash, if there was no injury, you wouldn't need a doctor, you wouldn't need a lawyer, you wouldn't need to take funding. So if you really are striving to help the victim, the personal injury plaintiff, then that's good. But you have to do it in the right way that truly benefits the victim, and not just some marketing platform or something that positions you to just get more clients. So let me know what you think. This is a new thing. I think it just was announced this week. It's interesting. So let me know what you guys think, and we'll keep following it, and maybe we'll do an update later on. But I thought it's interesting because it's something new, and it's cutting edge, and it's all about personal injury, and it deals with a lot of aspects. So it deals with personal injury case, the doctors, the fundings, the lien holders, pretty much all aspects of the personal injury world. Okay, everyone, have a great day. Thank you for watching our channel, and we look forward to speaking with you very soon. Okay, bye-bye.